General Aguilar, that as a spending condition, the federal government could have told Louisiana Department of Corrections that it had to include a clause in the contract telling individuals that they would be liable for damages?
Absolutely, Your Honor.
Why is this so different then?
It's different because, the word privity has been thrown around a lot on the other side of the case, and with all due respect, I don't understand that. When we're talking about consent in the spending context, you're asking whether the ultimate regulated entity has in fact consented to whatever the conditions are. And in your hypothetical, Justice Barrett, I think you can conceive of Congress saying, we're going to require you to basically require a contract of assumption by your employees, where anytime an employee comes into the state and says, I want to work for the state says in response, if you're going to do that, you have to agree to these specific conditions that the federal government has imposed on us. There is nothing like that contract in this case, and that's why I think all of those hypotheticals at the end of the blue brief about how Congress could have created direct contractual privity between a state employee in his individual capacity and the federal government doesn't hold up, because at the end of the day, what they're telling you is what Congress could have done. You don't see that line here.
But aren't they saying that if you have the contract and then you have RLUIPA on the books, that the combination of those things essentially is the condition that the employees were aware of?
Your Honor,
they signed up for the job?
Your Honor, that is not how this Court's spending clause cases conceive of consent. And I think every employee in the country would be shocked to learn that just by accepting employment with their employer, they have thereby personally bound themselves to contracts.
What state, damn it?
Go ahead.
What state remedies did these guards have? This was egregious. Is there a state RLUIPA?
There is, Justice Barrett. As
and
we
would
said,
that have provided relief to them if they had chosen to sue under it? As far as I can tell, they did not.
They did not sue. Arguably, the answer would be yes, Justice Barrett. At pages 13 and 14 of our bio, we describe our law, which basically mirrors RLUIPA, expressly provides for damages, and that was available. That's available to all prisoners in Louisiana, and it's available even to non-prisoners in Louisiana.
And it would permit money damages?
It has money damages expressly articulated in the statute, Justice Barrett.
Go ahead.
Well, I was just going to say that was certainly one remedy that was immediately available. I will say in terms of the broad scope of remedies available either to Congress, if it's unhappy with a state like Louisiana, or, otherwise, the remedy — sorry.
Yeah, no. I mean, I understand that. I mean, I just really did want to know as a matter of state law. And then just out of curiosity, obviously this is beyond the record. I mean, was there disciplinary action here? Do you know?
So it is outside the record, Justice Barrett. I can say the warden himself is no longer associated with the Department of Corrections.
Thank you.